Hello and welcome to the Mountford Chambers podcast. This evening we are here for International Women's Day, something that we all are very keen to celebrate within Chambers. My name's Fiona Clegg. I am one of the tenants in Chambers, and to my left I have
Alexandra Scott, another tenant.
Christina Courquin, a pupil here at Mountford.
Vanessa, Reid, a tenant at Mountford.
And Chloe Birch, also a tenant.
So the theme of International Women's Day 2022 is breaking the bias, and last year we'll all recall the theme was Choose to Challenge, which was something we discussed within Chambers, and we had a series of articles that were produced as well. And as you'll all be familiar with, bias really is an inclination or prejudice for or against one person or group, especially in a way considered to be unfair. And what we thought we would do is have a discussion and perhaps canvass some ways in which that's true of the bar, and particularly the criminal bar, and areas where that may come to the fore. And some of the unconscious bias faced, often institutional or structural bias, can be referred to as systemic bias. That does creep in, and I think we have perhaps all experienced that in terms of networking opportunities, sitting hours, the attempt, emphasis on attempt to bring in extended operating hours, and right down to raving rooms, single-sex raving rooms that have historically led to an exclusion to an extent of female advocates at the time of important discussions and negotiations, and how that may play out later on in a case. There's also consideration of microaggressions, something that perhaps we've all experienced to different extents, gendered language, higher standard of court attire to be taken so seriously. So if perhaps we kick off by considering structural or systemic bias and looking at the nature of the work and the courts themselves. We're very fortunate within Chambers that Chris Henley, Queen's Counsel, as our head of Chambers, when he was the chair of the Criminal Bar Association, something he flagged up and was quite a cheerleader for was working against antisocial hours and sitting times, and how this was slowly creeping in and the impact that was likely to have. Particularly when we consider caring responsibilities and those that are primary carers. It's often a case that it comes to just before 4 o'clock, and being pragmatic, a judge may suggest that we sit later, and of course that has a knock-on impact. So sort of opening it up to those that are with us for this discussion. What are your experiences of that, and how have you found it's perhaps best dealt with at the time?
Well, I suspect that for many women, and I'm probably not alone, I'm alone among them, the experience is that when you have that situation, you just keep quiet and send a panic email to someone else to sort everything out, and that's something which is obviously not ideal. I think it's worth emphasising when we talk about this kind of systemic bias. There's no suggestion it's intentional. Judges don't think I'm trying to penalise the female advocates or the caring advocates or those with caring responsibilities. It just happens. And I think historically, women have been reluctant to say, I'm sorry, I can't do that for childcare reasons, because they don't want to have held against them. But I have noticed in recent years and recent cases, men, and I make no criticism of it, actually flagging up their own childcare responsibilities and being perhaps more assertive about those responsibilities than I've felt able to be, and that's brilliant, and it's an example that we should probably take up as well.
And I can say, so I currently have a young child, and I'm also a relatively new tenant, and have certainly had the experience of being asked to attend hearings earlier than 9:30 or stay late past 4. And I have sometimes spoken up and said, in fact, I have childcare responsibilities and I really have to go at this time. It's been met with a variety of responses, and sometimes judges are absolutely helpful, and that's wonderful. But of course, the the pressure of not knowing whether you should speak up, whether that will hurt your reputation as a junior person. This is a profession where everyone works unbelievably hard. You want to be seen the same way. It clearly is going to have a difficult effect on junior practitioners if the responsibility is put onto them to speak up. And so it has to be formal policies. It has to be something that people think about before it gets to that point. Or else the responsibility will continue to fall disproportionately on women, on junior practitioners, and it will just keep on that way.
And touching on that, the policy point that you've just made there, Vanessa, from all of your experiences, what have you found that associations such as the Criminal Bar Association and Women in Criminal Law, how have they helped to assist with that, with putting in perhaps more global policies and campaigning for it with a far wider reach?
I think one of the really important roles that those organisations can play is that it takes it away from being an individual person, an individual request or individual circumstances, and it does exactly what this theme is about, breaking the bias. We're no longer seen in our gendered roles by those caring responsibilities or by those other responsibilities we might have on us. It makes judges or benches aware that those are responsibilities that advocates have. We, particularly in the criminal bar, are people who take the responsibility to our clients very seriously, and I know often most of us would put our client before ourselves or before our personal needs on a day-to-day basis. But when you do have requirements like childcare or something like that, you don't want to have to make that decision as an individual. And these organisations speak for women, for female advocates, although I hate that expression, but they are, to make that a policy-wide decision so that courts can properly allow and facilitate female advocates, I'm not going to say that phrase again, to properly undertake their role as advocates and as women with all the responsibilities that come with that. And I think they've done a really brilliant job, I say that with complete bias, in terms of standing up to extended operating hours, which would have a real prejudice against people who have caring responsibilities nationally. So I think they can do that and take it away from the individual and show that women need to be able to have equality in attending their job in the same way that men do. And I think it really has been heard and listened to across the profession. It's simply not going to work, and it's going to be prejudicial to women across the board.
And one of the other areas that we mentioned when we opened this podcast was in terms of the networking opportunities. And really within that, there's perhaps the ones within working hours that might exist from discussions in robing rooms, and those outside of the court hours, those within pubs, those within certain networking events and how they've perhaps traditionally been structured. Dealing first of all with those that take place within the court environment, and your experiences of the setup of certain robing rooms, and perhaps if we use Southwark Crown Court as an example, we all know from our experience at the Criminal Bar, it's a very fraud heavy court, and traditionally the large robing room within Southwark was geared up for male advocates, to use the opposite of the phrase Chloe's quite rightly against. And I recall from my own pupillage, I was fortunate enough to have a supervisor who was fantastic, but was being led by our head of chambers, equally fantastic. But they were both within the male robing room, and that of course presented its own barriers and challenges that they were brilliant at accommodating, but there was physically a door between where I was meant to put my belongings and where they were. And I think that it was in, I'll be corrected if I'm wrong, 2017, 2018, that
It still feels very recent, but I think it was a few years ago now.
Yes, and in terms of your experiences of either that robing room or larger opening up to other court centres. How have you found that has a bearing on your opportunity to speak with opponents, perhaps to meet instructing solicitors? What impact, if any, do you think that's had?
Well, you talk about that being 2018 or thereabouts.
I think it was 2017 when Judge Taylor became the resident.
So 2017, 2018, when I was doing pupillage, I too had a supervisor and was based at Southwark for the first 3 months, which was exceptional. But when I was there and I was shadowing him, and it was an all advocates robing room, changed by the post-it note on the door, we went in and a gentleman was there getting himself ready, and he double took when he saw me in shock, and he said, oh, I'm so sorry, I completely forgot that we have women, I'm so sorry, I've just completely forgot that we have you in here. And that was my first experience of realising that actually there is a bias, and there is a bias particularly in courts like that are fraud centred or are of particular kinds of cases. And luckily my supervisor didn't bat an eyelid, but it really did show that the seeing of women strolling around the robing room was a surprise to some, even in 2019-20.
Actually, I can jump on the back of that. I'm a pupil at the moment in 2022, and I went into a male robing room to find my supervisor because I was early and I was told to leave by one of the girls in there. At the time, I thought not a problem because I see them as changing rooms. I think in my generation of pupil barristerness, and I tried to see it as that. And my supervisor wasn't in there, found him elsewhere. And he is completely alive to the issue that he will never have any discussions in a male robing room because I can't go in. If he does need to go in, he'll come out quickly and we have all the discussions in the normal way. But it was the first time I've been introduced to that barrier, that I physically wasn't allowed in an area because of my gender. So I'm not sure if it is still an issue, as it were.
And in terms of that bias, particularly in a court that is heavily fraud based, which within itself can often have a high proportion of male advocates, how does that sort of play out into cases, perhaps discussions about the case and access to certain work? And if you don't mind, I'm going to turn to Alexandra here, who I know attended the Fraud Lawyers Association dinner, and sort of perhaps marrying the two in terms of access to certain conversations, the environment. What's your experience of that?
It hasn't been too bad, I'm going to be honest. Apart from anything else, I sort of feel that most courtrooms these days have communal spaces for advocates. So if you take, always has been the case, the Bailey, the conversations don't happen in the robing rooms in the same way they happen in the dining room. Woolwich, where they have the little robing rooms, but the reality is there's a communal area where conversations take place. So I haven't felt that to be too great a barrier. But in terms of shifting across to networking opportunities and into things like fraud work, fraud work is a whole separate conversation of bias potentially, but it's about chambers being proactive and making effort and making these opportunities available. And so, at the Fraud Lawyers Association dinner this year, we had 2 women from chambers in attendance among the 5 members of chambers who attended, which is 40% proportionally appropriate for chambers of our size with our current numbers. And that's the sort of thing where, thought has to be given as to opportunities for people to attend. And with all these things, there are going to be informal and formal, bless you, opportunities for networking. And sometimes a bit more thought needs to be given to the formal opportunities because, again, back to the carers point, if you have to make plans, if you have to put childcare in place, it's not enough to be able to say, just come to the pub after work and you can meet the solicitor then or spend time with them then, because it's not an option. So it sort of feeds into it in that way.
And Chloe, as Vice Chair of Women in Criminal Law, leading on from the point that Alexandra makes about networking and breaking the bias there of perhaps how traditionally it may have been done and how to make it more accessible, what sort of things have you seen develop in our Women in Criminal Law in particular, keen to help further along?
one of the things we've tried really hard to do is make sure that we haven't been biased in the other way, and we haven't done what might have been seen traditionally as female activities, and tried to make it really neutral and professional, because that's appropriate and that's exactly how it should have been. It shouldn't be that women are invited to men's activities as an afterthought, or that women have their own activities separately. It should be professional, because that's the kind of environment that we're working in. So we have panels that we make sure are really diverse in terms of age, stage, role, carers, non-carers, partners, trainees, you name it. And we try and get a real diverse range of people to speak at all of our events. And we also try and have events from the very bottom to the very top of both professions, so that whether you're just starting out or whether you're trying to be a partner, a QC, a judge, there is something to make sure that you can achieve that, someone that you can aspire to be and follow behind. And hopefully that means that there are opportunities at every level, and not just pupillage and traineeships, but for some of those top jobs and some of those top seats that should be filled with women as much as they should be with men. I think the most important thing about Break the Bias from that point of view is that although it's really exciting when we go into courts and the bench is all women, or there's a case and all of the leaders are women, for example, or something like that, that is really exciting, and you see people tweeting about it, and you see people telling each other, oh, you won't believe it, I was in a case today and all the people in the room were women. That is brilliant, and it's real progress. But it shouldn't be a surprise, and it shouldn't be exciting. It should be the norm. We don't go. I don't think men go home and say I was in a room of 8 men today. I don't think that's happening across the world, but it is happening when they're women. So I think that's the most important thing that we need to be doing now for the next jump up. Is let's make that the norm. I think Lady Justice Nicola Davies said the same thing. She had led. I don't know if that's the right word, she'd led the all female panel at the Court of Appeal sitting in Cardiff, and she said there were news articles on everything she'd read all about how incredible it was that it was an all female lineup, but there wouldn't be a headline saying it was an all male lineup. And so although that was fantastic, and she was, obviously proud as we all were to see it, that should be a norm.
And Vanessa, does that sort of accord with your experience, or is there anything that may sort of differ from that?
Well, I want to build on Chloe's point about the wonderful work that WICL, or Women in Criminal Law, have done, and also sort of the way it should be, which is one of the things that's wonderful about what WICL's done is that they have raised awareness. A signature issue of theirs has been pushing back against the extended operating hours, which we've touched on a bit. And many people, once they became aware of the fact that extended operating hours would, of course, have this disproportionate impact on women and carers, said, yes, we must do something about that. But it simply wasn't considered when it started to be rolled out, because of who is in those rooms and who is making those decisions. And again, with the best will in the world, if you don't have a diversity of voices and perspectives in those rooms, it just gets overlooked. And that's what I think is so important about these organizations that kind of do focus on issues affecting women, are organized about raising them, because ultimately the goal is not to need that intervention, but simply that we'll be thinking about those things at every step and say, how will this affect everyone, and not simply the decision makers in this room and what might cross their minds or might not cross their minds. So it's been wonderful to see the work of WICL, and I agree that hopefully at some point we'll just think about it before we get to that point.
That's such a good point. And Chrissy, you were talking about it earlier, and you were saying how actually it's not that there is this purposeful or intentional discrimination anywhere. That just doesn't seem to be the way. It's that our profession is so built on tradition and so built on the past, and actually a lot of us are very proud about that, and that's one of the reasons why we like the criminal bar so much, I think, some of us. But that means that some of those traditions haven't been changed, perhaps because women haven't spoken up or don't know how to, but it's about changing the traditions that have been there in the past.
No, I completely agree. Alexandra and I were having a conversation earlier on about the use of the word esquire which is a classic example of the traditional behaviour. All male barristers, once they're called to the bar, on their wig tin get the title Esquire put automatically on because they are male. Females obviously get no titles, and it's such a minute tradition that it's enough to put an automatic divide between a male with status and a woman without for the same job. So I do agree with you.
Whereas those of us who use old ice cream tubs, this hasn't really arisen.
And just touching upon something that you've all mentioned there, in terms of sort of who's having these conversations, who's in the room, I think we can probably all agree that in terms of breaking the bias, it's not something that it's just for women, it's for everybody within the profession. And we're very fortunate at Mountford that not only do we have that right from our head of chambers and throughout our senior male practitioners all the way down, but equally we have that leading from the front in our clerking room, and a recognition of that. And as Chloe quite rightly made the point, that it shouldn't be something that it is effectively celebrated every time it happens. It should be, this is the standard and this is the standard we don't depart from. In terms of your experiences of that and support that you have encountered in terms of breaking that bias, is there anything that sort of jumps to mind? And I open that out to all of you, really, without putting you on the spot.
Well, I might jump in again about being a relatively new tenant who does have a young child. That our clerking team has been amazingly supportive, and I feel incredibly comfortable communicating with them about if there are times when I simply can't do it, or if I need to let them know in advance. Clearly it's a give and take. I need to let them know in advance, as we all know. But I feel comfortable doing that, and I think that's a really key component as well when talking about changing culture, is that doesn't just come out of the blue. If you have no personal relationship with the senior members of chambers or your clerks, you're not going to feel comfortable speaking up, no matter how they would respond. So it is about building that sort of general camaraderie between all the members of chambers, the clerking room, and fortunately, we really have that here, and I've really felt more comfortable speaking up about my caring responsibilities in an environment like that.
I think more generally, and Vanessa, you're talking about caring responsibilities, but just being able to speak up at all, so that if something comes up, you have someone that you're able to go to, even if something feels petty at the time. And then obviously we've got, moving away from chambers for the moment, we've got Talk to Spot as an option which the Bar Council set up, which is a very useful tool just to log instances of anything from full-blown inappropriateness down to microaggressions or small issues. But a point that others have made is that just having the forum and ability and people who you can say that to makes an enormous difference, and it makes it seem, it actually makes all the issues less insurmountable.
I think that's so true. I think we're also really, really lucky to have such brilliant women at all levels, from top to bottom, in our chambers, that we can call upon and we can speak to about that from top to bottom. It doesn't feel as if we're isolated down here being juniors. We're
But
not.
men too, it's
Oh,
not
absolutely.
like, we can't talk to the senior men, we don't just pester the...
No, but we have those they're very firmly in the structure, aren't they, in terms of knowing that we have them above us to look up to.
I agree. I mean, as a pupil in particular, obviously I only started in October doing my pupillage, and it seems completely alien to me, the idea of a chambers where you can't vocalise any minute issue you have. On day one, it was made clear to me from male supervisor, you have any issues, you say straight away. If you don't want to say to me, you say to this person. These are the welfare officers. And straight away there was just that structure of, even if it's tiny, say something. We'll tell you if it is, we'll tell you if it's not, we'll deal with it. And I think having that in place is what really makes a difference with the chambers, and will make a difference in the long run to all the newbies coming up. So
Well, it's been wonderful speaking with all of you. Thank you very much indeed, and we can only hope to keep going in the same direction as we do break the bias, and we're very lucky to be where we are, and long may it continue. So thank you all very much.
Thank you.
Thank you.
Thank you.